Mm. Mm. So just waiting for one of our panelists to, step in. That's Vikrant. And we have Jonathan already on the screen, and then Mr. AJ Jawad. We'll be expecting him any moment. One of the short guys, and he's shuttling between many invites. And let's hope that we are lucky to have him as well at the earliest.
You are not audible.
Okay.
ABL Srivastav, I joined. How, Mr.
Yes.
Dev?
How are you, Mr. Srivastava? Good to see you. So you're enjoying in London, right?
And
Great. No, we need to speak, I guess, maybe if, sometime tomorrow, just drop in a message, we'll have a chat. And so I'll, give the background about a couple of people we can, talk to and that part.
sure.
Okay. So we just take a couple of more minutes because one of the
If you want to
panelists,
start, you
I
can
see.
start. I'm in the
Yes.
car, but I've got my camera on. I don't have a problem. I'm not
Okay,
driving.
perfect. I think that suits Vikrant. I think that's good. We were
Okay.
waiting for you.
That's
So
fine.
lovely. Okay,
Because I'll
great.
take a couple of minutes before I reach the office. So
Yeah, that's fine.
interview.
So maybe in the interim, I'll put some questions to Jonathan to start with. But anyway, so very good afternoon to all of you, and actually good evening, Mr. Srivastava. For you, it will be what, good afternoon, I guess, right, in London.
Yes.
So let's see, like, this invite has gone to few people across. So as and when more join in, we'll have to keep wishing them good morning and good afternoon. So we at IMF, we are back with another webinar on a topic which is related to mediation. And of course, today is Mediation Advocacy Day. We'll be talking to some, veteran stalwarts who have been pushing this concept of mediation advocacy all across by being a example themselves and by, like, through their own platforms, own setups. And that's something very interesting because mediation alone cannot meet the objective unless until it's supported through a proper advocacy and a professional who dedicates himself to be a mediation advocate is so important as a contributor for the larger cause. So from that perspective, the topic is very important. Today's session, today's webinar, we are doing, Indian Mediation Federation is doing along with Indian Lawyers Association. So allow me quickly, I'll run through a couple of lines as to what IMS stands for, what is ILA all about, and then a quick introduction about three panelists, and then from there on, we'll straight away dive into the questions to the panelists. So the Indian Mediation Federation is a national initiative to connect all stakeholders across the mediation ecosystem and of course across the country to bring together some consistency, transparency while we promote mediation as the first port of call. And we help India to lead from the front end, of course, with examples. We want IMF to be that umbilical cord which connects all the possible dots that are relevant, including the service providers as well as the users, in the space of non-adversarial dispute resolution. With regards to Indian Lawyers Association, is one of India's fastest growing voluntary professional networks, bringing together advocates, judges, academicians, in-house counsels, legal professionals, and of course the law students through more than 100 chapters across the country. ILA is dedicated to promoting professional excellence, ethical legal practice, continuous learning, and meaningful justice reforms. Through national, international webinars, conferences, publications, and collaborative initiatives, it provides a platform for thought leadership and constructive dialogue on issues of legal and public importance. Now, with the vision of contributing to a faster, fairer, and more accessible justice system, ILA continues to connect and empower members of the legal fraternity across the country. Then, some quick introduction about the panelists. So we are waiting for Mr. Jawad. I'll quickly, give his introduction. We should be expecting him any moment.
Sanjeev, I have joined.
Oh, lovely.
I have joined, but I'll be keeping my camera off because I'll be really sorry. Okay.
Your voice will do the trick. You bet.
Thank you.
Right.
Yeah. Good evening to everyone.
Okay, lovely. Great. Thank you. So he's a senior mediator and a MCPC trainer at Supreme Court, having trained judges, lawyers, and professionals across the spectrum. A rare example of a full-time lawyer shifting to full-time mediation and leading from the front. Currently, is also has the important role of being the registrar of IAMC Telangana. Then we have Mr. Vikrant Pachananda, who's an advocate on record in the Supreme Court of India and a special public prosecutor for the Central Bureau of Investigation, CBI, with, of course, offices in New Delhi and Chandigarh. He's a member of ILA Delhi Board. He's an alumnus of Cornell and Leiden universities, and he has authored 3 books, including 2 on aviation law, apart from also publishing several articles in both international and national journals. So welcome, Vikrant. And we have Mr. Jonathan Rodriguez, who's a mediator and a founder of PACT, an institution, a platform which has been promoting mediation advocacy and leading from the front by conducting a mediation competition for legal professional students and getting them their first taste of mediation as a concept to be embraced and implemented. So it's me, Sanjeev Ahuja. I'm founder of Missing Bridge, a boutique advisory firm focusing on IBC, that's insolvency, mediation, and stalemates. As a representative of IMF, I would moderate the session, trying to ask some tricky ones to the panelists we have today. So straight away, we jump to the questions. And with regards to the housekeeping rules, I guess we'll have a Q&A session towards the end. In the interim, I request to all the participants to keep themselves on a mute. Thank you. And do I see Mr. Malhotra? Mr. P.K. Malhotra? Welcome, sir.
Hello, good afternoon, everyone.
So nice, so nice to have you, sir.
No, I'm there right from the very beginning, but the display was not there.
Okay. So before I get started, of course, Mr. Malhotra has joined us. That's wonderful. He's the chairperson of Indian Mediation Federation. Sir, couple of minutes to you, sir. Please, in case you want to address, we have participants from all across. And this the topic for today's mediation advocacy. So it'll be nice to have your views on this.
Thank you, Sanjeev, for this opportunity, and I'm happy to be part of this dialogue today, which you have initiated and involved the Indian Lawyers Association, also with the Indian Mediation Federation. And you have already given a brief introduction of what the Indian Mediation Federation is doing. And today's topic becomes very important when you say role of lawyers in the non-adversarial dispute resolution space, mediation advocacy. I think this is a very important topic which we must deliberate, and what is the way forward for all of us. Why it is important, I say, is because of the India's litigation scenario, which by any standard, nobody will say is a happy scenario. With 5.5 crore cases pending in the courts, I think getting justice, or rather expeditious justice, is a very difficult proposition. But at the same time, India has always believed in ADR mechanism as a better mechanism for resolving the dispute. And in addition to arbitration, we have been promoting conciliation. Our local laws are there for holding Lok Adalat, that is the public court, and the Gram Nyayalayas. And mediation has always been considered a better mechanism for resolution of disputes. We had many legislations, including the uh, uh, court-monitored mediation and the MSME Act, Companies Act, Consumer Protection Act, and the Commercial Courts Act of 2015, which are particularly devoted and make provision for mediated settlement or mediated resolution of disputes. And in 2023, we came out with the standalone Mediation Act. The idea is very clear. With the legislative framework in place, now I think the time has come when we in India demonstrate how mediation can coexist with commerce, governance, and community, and how it can strengthen business confidence, it can reduce litigation burden, and reinforce trust in institutions.
Right.
And on the platform of Indian Mediation Federation, we intend to channel this momentum into a, I can say, structural, credible, and inclusive platform that brings together the legal professionals, mediators, businesses, and the stakeholders. It is a hard fact of life that any person aggrieved by decision want to get his dispute resolved, and his first point of contact is looking for a solution through advocates who becomes his guide, philosopher, and mentor to suggest future course of action. Hence, any resolution mechanism, if it has to succeed, must be supported, promoted, and advocated by the advocates in addition to the other professionals. Just to give an example, even Abraham Lincoln, he has also said, I think mediation or the conciliation is the best way of resolution of disputes because it results in win-win situation. I'm also reminded of Mahatma Gandhi when he was practicing in South Africa. I think most of his practice, which he has written in his autobiography, was relating to, he was a votary of dispute resolution by the lawyers through mediated settlements. And I think he succeeded a lot in that area. And in today's scenario, when we have technical expertise available, but that kind of technical expertise may not be available with the courts. So is it possible that we should involve lawyers to help in promoting non-adversarial dispute resolution and help even in reducing the burden of the courts? I think this is the theme of today's discussion, which we in IMF have proposed in collaboration with Indian Lawyer Association. And definitely you have called very good people. I think Mr. Jawad, who is associated with us in the IMF and is also associated with the Hyderabad International Center of Arbitration and Mediation, Mr. Vikrant and Mr. Jonathan. I welcome you all the panelists. And definitely, I think we in the IMF will be interested to hear their views as to how best the legal community, more particularly the lawyers, can help in promoting mediation. As I said, legal framework is already in place. How best we execute it and how best it is received by the litigant as a dispute resolution mechanism, I think that is what we are supposed to do. Thank you, Mr. Sanjeev, for giving me an opportunity to give my introductory remarks. I think because we have some time constraint, we will definitely would like to go with the panelists on the subject. Right. Over to you, Mr. Sanjeev. Thank you very much.
Thank you, sir. Thank you. Okay, so we'll jump with the questions to our panelists. Let me start with Vikrant. Vikrant,
hi.
Hi. The right question is, does an average advocate going to a court every day believes in mediation?
Well, I think, it's a very subjective question because it actually depends, on what the client wants. Yes, as lawyers, we at times do tell our clients that if you want a peace of mind, you should definitely try and settle the matter, especially if it's something like a family dispute or a property dispute amongst family members, where ego often comes into play, and where so those kind of matters, we definitely do try and convince clients that, why don't you try give mediation a shout and give it a shot and see that, whether you can put your differences aside. I think when you're doing mediation, again, what is very important is to also explain to the parties who we represent that, mediation is coming to a mid path. It is giving up something and not you, because in a mediation, each party has to sacrifice a part of what they want of the pies that they're looking at getting. So that is again a challenge to convince the client, because they think in a mediation, each party thinks I am right and therefore I should get my full share of what I want. The other says, why should I get my share? I am absolutely correct. So it's again, that's also a problem to, try and convince the clients that, you have to give up something for getting that peace of mind. Else you need to fight it out. You'll have to wait for 10 years, 15 years, for as long as it takes. Now that is maybe disputes where, your family is involved, where you can settle. Again, maybe disputes which are between companies, again, are disputes which can get settled, and where I would urge that, parties should try and settle it out. In fact, in the long run, a settlement is also, I think, very beneficial, because otherwise people don't realize the humongous interest that they have to pay today. If you're on the losing side, the interest that you pay at the end of those years, which is difficult to calculate in the beginning, is something which has to be seen. Of course, matters like criminal matters, of course, those are matters where you cannot really, get into mediation. But definitely, I think inter se company disputes and matters which, your family is involved, whether they are property disputes or whether they are family-related matters like divorce, child custody, these kind of matters, definitely, I think we do tell clients to try and settle it out. We do that, yes.
So, the reason I asked you was that, you go to an environment every day where, amongst the noise of the arguments, where everyone's trying to prove I am right and I need to win. Is it not the message which also goes from that advocate to the party that, like, since you've prepared your draft and, you're pleading so nicely, you are right, you have, like, full marks and the chances of you winning are very high. So amongst all that, how easy or difficult it is for you to even, like, parallel think that, guys, can be settled? Should we even look at that option? So that's where, like, the question came.
Right. So see, the thing is that sometimes a matter never finishes in one hearing. Sometimes, we do, when clients come to us in the beginning, we do tell them, are you interested? In the beginning, that's their ego which usually plays, and they say, no, let's fight it out in court. You are well prepared, yes, but then what happens is, I'll give you an example. I'm doing a matter where I'm appearing for a brother against a sister. Both have properties all over the country, including hotels. Parents died. Both parents died during COVID without a will. And that's how the whole overnight, their litigation started. And I represent one of the parties, and similarly, the other party is also represented by a lawyer. And I told the client, I said, are you sure you don't want to settle? Not at all. I'm absolutely correct. My sister's got her share, was given by the parents much before. So irrespective of there being no will, it's all clear between us. I said, okay, fine. We fought the matter. We had a good case. I got an an ad interim order, which was an ex parte ad interim order against my client, which had been passed at the time of filing suit. I got that also vacated me, which is very difficult otherwise, meaning that pending the outcome of the matter, I can still dispose of the property in dispute, which usually never happens. But then, automatically the other side went in appeal. And we were stuck against that one order, remember. So these property matters, for instance, one application which gets disposed in your favor goes in appeal, means you can have many such parallel applications can be filed, and you can have parallel litigations from this. So they go in appeal in that or against that application. That appeal takes 2 years before that again comes in my favor. There's still a chance the other side could go to the Supreme Court. We don't know for that. We don't know. Right. So what I'm trying to say, that's when I tell my client, I said, see, I told you right from the beginning. Now you understood. You may have won at one level, but then they go and appeal. You're stuck for 2 years. okay, we were lucky we won. Had we not won, we would have gone to the Supreme Court, definitely. We would not have kept it. I said, we won. They might still go to Supreme Court. And this is one such application in a suit, for instance. Tomorrow, another application could be filed, maybe by the other side, which goes against us and we want to appeal, or vice versa. So it's actually going to be a never-ending process. The matter is never going to be disposed of in one hearing. And I said, we are still at the lower level before the single judge of the Delhi High Court. I said, eventually with these parallel litigations, by the time your suit gets decided, you're going to be 6 or 7 years down the line. Then against the main judgment, there could be an appeal. I'm sure either party would appeal to the division bench of the High Court and then Supreme Court. And my client, for instance, keeps traveling. He's based all over the world. It's very difficult to, in fact, get him in Delhi. In fact, during the mediation was such a challenge getting him to appear in person, for the in-person meetings. And that's when he realized, he said, you are correct. Let's just give another mediation a shout. The first mediation, both parties had their egos and, it didn't go through. He said, actually, let's do that because I've realized. He's like, my children live in Canada. I don't want my children to inherit this. I'm sure the other side, her son also lives in Canada. I'm sure she doesn't want him to inherit this. So, let's just try and do a mediation again. And, I've realized the fact that even though I might be right, I need to give up something more, So I think that's where it comes up. Some of them understand in the first go. Some understand during the course. So even though, we've been successful so far, but just seeing how long it's lasted already, and we're still in the beginning, the very first step, which is the interim step of a matter, so automatically, I think sometimes they do learn it the hard way as well. The only problem happens is when you have a government entity on the other side, because that becomes a problem, of course, because they are not willing to give up on anything. That flexibility, for them, it's not a mental peace of mind. One officer comes, he's there for 1 year, he gets transferred, somebody else takes over. So there's no personal stake involved for anyone. They're all afraid that vigilance inquiries might come against them. Maybe because again, settlement means you lose out on something. You can't start going by the contract and say, okay, if my claim is 2 crores, I want 2 crores. If I settle on 1, I might have a vigilance claim that we've given up on 1 crore. So might as well, fight it out. So that is a problem, unfortunately, on the government.
That's a different ballgame altogether, because
yes.
with regards to government, as rightly labeled as the biggest litigator, that's a systemic issue and which needs to be treated and debated separately.
Absolutely, it's a separate issue. Absolutely.
And in your answer, I think few things have come out: the time, the fatigue factor, the uncertainty, the actual objective of solution versus justice. So we will come back to those. So let me just shift to Jonathan. Jonathan, we've been hearing, "I'll see you in the court." Now this has been there forever. So now it's become the first statement somebody has an issue, whether truly there are legalities involved or not. But the moment you have a tiff, a dispute, a conflict, what you hear is, "I'll see you in the court." How, as a mediation advocate, we need to address this? Easy one for you.
I think it's a very tough one, actually. Thanks for having me, Sanjeev. Good evening, everyone. Mr. Prithvish, I really admire your dedication. I hope you're keeping well. That is that is a lot of dedication to be part of this webinar. So I appreciate that. God bless you. So yeah, I don't know. In terms of getting change that approach of "I'll sue you" to, I used to use this phrase when I started my mediation career 10 years ago. I used to say, instead of saying "I'll sue you in court," you should say "I'll see you outside court."
Yeah.
Which also sounds a bit confrontational if you're planning to box the person.
True.
But or punch the person in the face. But what I was trying to say was that let's take a very kind of practical turn to this in terms of how can you change the attitude and approach. Even when we talk to lawyers now, I'm actually in the process of working on a module to kind of bring in lawyers to the table and talk about what their role is in the mediation process, right? I run a mediation advocacy course where we train lawyers to represent clients in mediation. And one of the things that we speak about is that the language has to be collaborative right from the start. A lot of lawyers come, even to me as a mediator, and they'll say that, we sent a notice to the other side for mediation. And I said, you lost me at notice, right? Because notice is not an invitational word. In the world of legal jargon and verbose, the word notice has never been welcomed with open arms. It has a wrong, and we have to accept that. It's the origins of the word doesn't mean it's a negative word, but in the legal context, the word notice always comes with a negative tone. So when you're sending someone a notice to mediate, it's already wrong. It has to be an invitation to mediate, right? And sometimes they'll show me some of the mails that they've sent to the other side and see we try to reach out to the other side and call them to mediation, but the whole email is so hostile. It's so hostile. It's full of threats. It's full of positions. It's full of demands. And there's one line in the end that says, we can try and resolve this to mediation if you want to. That's not an invitation at all. That's threat, right? So I think it starts with those kind of I think when you are convinced that mediation is the right tool and right process for your client, then I think you should convince your client that let's take the collaborative tone right from the start. Right. Let's, even whatever emails we share with each other, let's make sure that we are keeping the hostility down to a minimum as much as we can. Let's try and de-escalate the tone and the language that we're using, whether it's via mail, whether it's via WhatsApp, whether it's via call. And I think it starts with that. This might sound very trivial, but trust me, these things matter. In the end, the numbers game and the legal technicalities and all that stuff is fine. The reason why most of us as mediators struggle to bring parties to a settlement is because it's these interpersonal dynamics that always come back to this. There is this theory in the negotiation world. It's called the peak end rule. I don't know if you've come across it. In any conflict, you always remember. So I have a slightly different twist to it. I call it the start, peak, and end rule. In any conflict, any conversation, whether it's something small or something massive, huge, you'll always remember how it started. You'll always remember the most intense moment, the peak moment where you might have like cursed at each other. And then you always remember the end moment when it completely deteriorated, right? So at least, so knowing that people remember always the start to it and the peak and the end, I think as soon as we see the signs of conflict, we should try and de-escalate and keep that collaborative tone. That's the first rule for any lawyer trying to take their client to mediation.
Fair point. What about...
Sanjeev,
yeah, so go ahead.
Sanjeev, may I say something?
Please go ahead.
See, we are talking about mediation advocacy, right?
Yeah.
I deal in cross-border cases. Right?
Mm-hmm.
And the concept of mediation is totally different in UK as it is in India. Right? In India, we talk about, like Jonathan was saying, figure out problems. In UK, I was there just for twice this last few months, and they're all about, okay, mediation means sort out the problems of finances, and that's it. Okay. Now, to tell you something very, very clear, I actually, the couple is married in Delhi, right? And he waited for almost 2022 till such time that, no fault divorce became a rule in UK, right? And then he applied for that. So we applied for a anti-suit injunction from India. We got that, right, from Dwarka Court. Mm-hmm. It was escalated to the High Court, Royal Court of Justice in UK. Now they are talking about giving an anti-suit. And we are talking about anti-suit.
Mm.
It's becoming a war of suits, anti-suits, right? One person says, see, the Indian laws are codified in the Hindu Marriage Act. You can't go beyond that. Right? Yet, comity of courts is there.
Mm.
Yet, somebody up there in the High Court says, I'm giving you so much time to withdraw your appeals, whereas we already have here. So my question here is not the legality of it. My question here is, we all talk about mediation advocacy, we talk about mediation. How do we define it in terms of cross-border cases. And today we have to accept that people are, settled abroad, married here, settled abroad. There are so many issues which are coming up that I frankly feel that we are actually losing the plot in some manner, Sanjeev. I'm sorry.
Point well taken. My only thing is we'll slightly have to probably come back, and this is something which was discussed with one of the recent discussions I was part of, where we were getting into what exactly is happening cross border. Are we all trying to define the concepts and are we applying them in the way they need to be, or everyone has his own definition, right? And suiting the context at times. So somebody who's who has more legal knowledge, somebody has he's aware of the legislation, he defines it differently versus someone who is a non-legal professional and his approach is going to be different. So including the cross-border as well, including the background what we have with regards to when we come forward and we try and define mediation or mediation advocacy differently. But the idea was that we were wanting to have a separate discussion on this thing. And for now, I would just park it, right? I mean, with the permission, right? Okay. Mr. Jawad, can I just come to you and ask a very, very, very important question that a full-time lawyer, a full-time advocate, one fine day decided that enough of this, I need to shift my mindset, shift my objective, my approach, and be a mediator. In between, of course, you've done a lot of mediation advocacy, and you've trained people, you've trained judges, and you've trained students and professionals all across. What is your take with regards to the role of an advocate in the mediation ecosystem? Of course, including the mediation advocacy. You able to hear me? Do I see him?
Sanjeev, you can probably repeat that, and maybe me and Vikrant could.
Of course, I need to now, move to you guys because I don't know. I could see him on the screen initially, but apparently maybe he's dropped out or something. So, Jonathan, do you want to take this?
If you could just repeat that question for me, Sanjeev, please.
So I mean, it was immediate, directed to him because he's moved from being a full-time lawyer in 2010.
Right.
He says, now going forward, I'll dedicate myself to mediation. In between, he's been a mediation advocate, he trains, he's a mediator as well. Now, what exactly, in terms of the role, how this role of an advocate in this mediation ecosystem has evolved? So that was the question to him from his experience, but now putting it to you, you can also share your views.
Yeah, I have a different story. So I never practiced in court. Ever since I graduated, I knew I didn't want to do that. I took a vow very early on that I would be dedicated to mediation. So I have a background in psychology as well. So I think the question is, what is the role of the lawyer in a mediation, which is quite distinct from a role of a lawyer in arbitration or in litigation.
Yeah.
Right. And as I said right from the start, you need to have that collaborative tone, right? You need to know that you are the emotional anchor in the room, right? That's one of the biggest skills you need to have as a lawyer in mediation. You have to be the emotional anchor in the room. You can't be getting emotional like your client. Okay. Then if both you and your client are emotional, that mediation is going nowhere. So you have to be the one with high emotional intelligence. You should know to calm your client down, to make sure that you're having your client operate from their rational brain and not their emotional brain, right? And for that, first of all, you need to be calm. You need to make sure that you have given yourself the chance to be in the right space and right safe space. I think the role of a lawyer in mediation is kind of, it starts quite early. It starts from the pre-mediation stage where you need to prepare your client, work with them on a strategy, prepare them in terms of their mental preparation, their emotional preparation, their psychological preparation. Ask them what the other person might say that might trigger you or get you angry or get you upset, right? Ask them very clearly what their true interests are. It's not about you. See, when you're in court or when you're in arbitration, you're always fighting on the technicalities of and the logic of the dispute, right? But in mediation, it's much more than that. It's interpersonal dynamics. It's it's emotions. It is the why you want what you want. When you're in arbitration or litigation, and maybe Vikrant will agree with me on this, that it's mostly the what you want, and and why do you deserve it. Whereas here it's much more. Here it's about it's not just why you deserve it, but it's about why this thing is important to you. What are the interests? So I think the counsel has to spend a lot of time with the client, understanding the true interest, preparing them for the fact that this is going to be a win-win situation, that the other side is also going to win. This is why I talk about the psychological preparation. This is easier said than done. If you don't prepare your client to know that the other side is also going to get something from you, the other side also expects you to give them something. You have to give to get, and you have to prepare your client for that. Because if you don't prepare your client for that, then the client doesn't have the right expectations of mediation. And I've had so many situations where clients come up to me, or counsels come up to me and say things like, "Tell the other person that they're speaking nonsense." I was like, "Who do you think I am? Like,
Yeah.
am I some school teacher or some kind of what do you? I'm not in that position to be schooling someone else or giving advice or arbitrating in that situation, right?" So I think you need to prepare your client in terms of what to expect from the process and what to expect from the mediator. Two different things, right? So there are a lot of, I can go on and on about mediation prep. I spend a whole half day in terms of what the skills are for a mediation lawyer in a pre-mediation stage. Then in the mediation stage itself, you should know how to navigate through the different stages. There are joint sessions, there are private sessions. You need to get through all that. And finally, I think in the last phase is where when the agreement is reached, you should be the one who is vetting that agreement and making sure that there are no loopholes. There is a clear-cut understanding in terms of the execution of that mediation settlement agreement. And one thing that I always say to a lot of people, and even as a mediator, I make sure both sides do this. You sign the mediation settlement agreement, put a clause there right in the end that says it's almost like an insurance clause. Okay? It says that in the process of executing this mediation settlement agreement, if at all we do find ourselves in another conflict, we'll come back to mediation to sort it out. And we won't rush to court. We won't rush to court, or we won't rush to arbitration to execute that. Right? We have built a goodwill. We've tried to rebuild our relationship, a business relationship or personal relationship. And so in the execution, there might be some other difficulties that we might face. So let's not rush out of this mediation. Let's come back to it. And therefore, you're ensuring all the work you have put in, all that hard work doesn't go to waste.
Doesn't go to waste, absolutely. No,
So that's my 2-day workshop in 5 minutes.
Yeah. Thanks. But the takeaway was very nice. I mean, having that last clause which works as insurance, because, you put in that labor, that hard work to be on the table with the mediator, and you've run through the process. Now you're successful and probably executing a settlement agreement. Now, the last thing you would want is that, God forbid, something goes wrong. You don't need to rush to a court and undo whatever you've done in your entire this effort. So this is good, but the very reason I wanted to ask this question to Jawad to start with, and then of course to Vikrant, and finally I was to come to you. The reason being, you have only one level of baggage. You said you are a lawyer, but you've never practiced. Imagine someone who's been practiced in a court, going to court every day. So two level of baggages. One, we all got educated legally through our, law colleges, where we said, okay, these are the arguments. That's the way you, put citations. That's the way you make your pleadings and everything. And the second thing, the second package you have is, once you go to the court, you have to win. You have to frame your arguments. You have to have that one-upmanship, because there's the other guy, your contemporary on the other side, who's also trying to get his piece out of that pie. So that two-level baggage, how do you undo this? And this was that was the reason I thought we'll get some insight from Jawad. But let me ask Vikrant the same question. Do you see it's let me not say inconsistent, but to an extent, yes. We've studied law differently. And then once you start practicing, objective is to win, because you go with that mindset early in the morning that I am right, I need to win this. Okay. In the process, somewhere down the line, you say, no, let me tell my client, can we do a settlement, a give and take? Okay. Because if you are in your mind, you are convinced, confident that you are right, and that's the message you are sending across to your client, and everyone is right, and you're fighting to win. Where is the scope left to let go of anything?
Well, what happens a lot of times is, you're litigating, you're confident of a good approach, and you feel why give it to the other side when, you can do it. But courts also are, very unpredictable. Sometimes, you have to play it by the ear. That moment, sometimes the hearing might go south and you feel, okay, you realize that, okay, this aspect you hadn't thought about. Or, sometimes, you have hearings which are going your way, but suddenly you realize the other side has paid a strategy to, you know, delay the matter, or you suddenly hear that company, like for example, I was doing an execution for a proceeding for a party. Execution meaning I'm filing just to enforce an award, and I to enforce an award, and then a scope, and that is when I won. That's why I filed an execution. And that is when, we hear that, that party might be filing an NCLT for insolvency proceedings, meaning things suddenly could take a U-turn all of the sudden, in spite of me having an order in my favor. So, that is one step ahead, where I've got an award or an order from a civil court, a decree in my favor. I'm only executing it, and suddenly something happens. So immediately, I told my client, if they offer you settlement, which they had initially, I said, you get back to them and say, now I think it's time, because, if you get stuck with insolvency or something, then, your execution remains pending. You may not get the entire amount, so it's better to settle. So a lot of times, things happen where, you feel you have a good case and you're doing, and suddenly something happens during the course of litigation. The other side takes advantage of some other law which is there, and you use it in his favor, and you don't expect him to do that, or you play it by the ear, and you suddenly see, okay, this is coming. I think let me just now advise my client, because otherwise what he's entitled to and what I have a good case to fight on, if today I have something like an insolvency and moratorium proceedings kick in, I can't fight that matter anymore. So those factors do come into play at times, and suddenly you have to change your strategy depending on. It's a very momentary thing, At times, you like you had asked, sometimes it's right from the beginning, let's try and settle, and sometimes it's based on strategy, where suddenly you feel, you have a good case going on, but something like this comes out of the blue. The other side has played their cards right. They know, they're on the losing end. They know you're not coming to settlement as well. You're not coming to a mediation. So let's play our cards in a different manner. Let's use some other law in our advantage, which either forces him to settle, or otherwise, he has to then face whatever music he has to.
Right.
Vikrant, can I ask you one question?
Yeah, sure.
Sorry. I met Sanjeev in Delhi a couple of years back. I asked him a question which he still hasn't answered. Right. So I'm hoping that he can answer it today. We're all part of this mediation process, the litigation process, everything else, right? How many of us truthfully feel like we're actually, at the end of the day, collection agents from the bank?
Well, I would put it differently. I don't think you're a collective agent, because I feel, it's a collection agent rather, because I feel, if you decide that, you want to mediate, I mean, a mediation is a part of, it's a form of alternate dispute resolution. So it's something which is, embedded in the system. If you're into dispute resolution, it's just an alternate way. And it's not the question of a collection, because eventually it is the parties who take a financial call on how much they want to settle. But I think where a lawyer's role comes in is where you explain to the client what are his chances of winning or losing, or he may be winning, but because there are some other laws which the other side can take an advantage of, which might delay his proceedings. So I think that's where the legal role of a lawyer and legal acumen comes in, because you tell your client that, okay, and like, for example, I gave the example of insolvency. Okay, now he's playing the insolvency card because he knows on merits he has a weak case. This is what the insolvency law says. This is where I can get stuck. This is where I may not get my money back, or I may take years to get my money back. Or this is where, I won at the interim stage and he's got an appeal. And this appeal itself at the interim stage can go on for multiple years, because there are 2 stages to that interim appeal itself. And once that gets decided in 3 years, I come back to stage 1 of my petition. So that is where, as a lawyer, I feel your role comes into play. You advise them. It's only after you look at the entire legal scenario surrounding you do you take a call if settlement is better. Why? Because the question is, does the client want a complete change in their mind? They want to be completely carefree. Clients don't want to pursue the litigation. They feel they don't have time for it. They feel the time they're spending is consuming more money than actually what they're paying lawyers and what they would get out of the litigation. So I think that's where the lawyer's role comes in, that if that is what the client is looking at during the course of a matter, which he might not have had that outlook right in the very beginning, the lawyer can advise him on that based on how the situation is. Because if you need legal acumen to take a call whether you should settle, or you should not settle. And if you should settle, how should you look at the settlement? Eventually, the financial terms are the client's call. So there, today it's the client's call eventually at what amount they want to finally settle. So then it boils down to that, whether they want to come down to that amount or that prevails, or they say, they want a carefree state of the mind.
Agreed with Grant, but
So
the
that's
problem
how I would look at it.
No, I totally agree with you. The issue is invariably clients come and say, "Bas humko itna dila do yaar."
So I think that's where the lawyer, has to kind of step in and say that, okay, see, I can't guarantee you any amounts. I can't guarantee you the success in the litigation. You have a good case, but at the same time, a good case can also go south. You never know what comes up in court. And secondly, I think that's where you have to put your foot down and tell him, see, I can't guarantee you the success in the litigation. And yes, if you're looking at settling, I can tell you the pros and cons of whether you should settle or you should not settle. At times, settlement can be a bad idea as well. So, so therefore, you can advise him on whether he wants to settle or not. And once that comes into play, depending on how good a case he has and the upper hand that he has in the settlement, you can then tell him that, okay, this is the amount, you can look at. The rest is then up to the client to eventually, sit with the other side and work it out.
Absolutely. That's
So, my two bits
that's the
would
point
be,
I'm trying to say.
yes, absolutely. And, as Vikrant rightly said, it's very difficult to use a term called guarantee. Every client, whether in mediation and or litigation or even arbitration, what do they expect? They expect some clarity, some certainty, some finality, but beneath that, what they're looking at is, can you guarantee me this? Now, no lawyer, no mediator, no mediation advocate,
Absolutely.
none of you can actually guarantee anything. Okay, so essentially what we need to, and tell me what is right and what is wrong. It's always in hindsight. I wish we've come across people who said we'll do wrong. We want to commit a wrong. Nobody wants to. They want to do the best. They want to do what they feel is right. They are convinced. They convince themselves and they move ahead. So that is where, there's a lot of debate. Do people require justice all the time, or they're happy with the solution? Because justice needs to be defined differently.
I'm glad you said that word, used that word, justice, right? So, sorry.
Yeah, I know. I mean, okay. The thing is, it goes on in a different tangent, but these are important discussions.
The very word justice. Okay.
Yeah.
I've been somebody who's told my clients, as a citizen, justice is not something that the judicial system can give you. It can give you the least detrimental alternative as a solution, right? Justice is something that we cannot give you. So don't come to us for justice. Come to us for settlements. Right.
In fact, I always tell clients when they come to me, I say, see how much you can settle, because, doing multiple matters in a day in different courts, while I would not say courts don't give you justice, I would maybe rephrase it. That's my personal perception.
Yeah.
Justice takes long, and you have to have the patience for it. Clients, are pumped up right in the very beginning, and then they start losing hope, even if they have a good case, because of the whole time-consuming process and because of the system that we have, of multiple appeals and unfortunately, because our courts are overcrowded, the government being the biggest litigant, judges do their best. I mean, in Delhi High Court, for instance, they are sitting till 6:30, most of the judges. But I mean, they are humans also at the end of the day, and it is not possible to decide to finish. To decide all the cases on a day. So therefore, I would say justice is very takes a very long time. And of course, the other, and a party which, has a party which has a dishonest intention, because, since I do work on the criminal side and, I appear both on the prosecution and on the defense side, I can tell you, for a fact, at times you have clients, who have a dishonest intention. And then you are looking at, delaying matters using, of course, legal means. Whether it is, filing, whether it is filing some application under some law, some application, there may be applications which may have no merit, but then again, once you file something, then that has to be heard. The other side has to respond.
Yeah.
You file a rejoinder, it requires hearing, and eventually it may get dismissed. But but the person who has a dishonest intention buys another 6 months to 7 months. Then he does the same thing again. Then sometimes, you have lawyer strikes that happen. So, or something of that sort, or something like that. So therefore, but unfortunately, I wouldn't say justice is not given by courts, but justice takes time. And I tell clients this all the time, if you can settle it and give up on something, please do, for your mental peace of mind. Otherwise, you're in this for a while. I mean, I wouldn't say you won't succeed, but definitely you're stuck for a while.
No, fair point.
Alternate dispute resolution is the only way to justice.
Well, again, this debate can go long, but please, Jonathan, yes, go ahead, and maybe I'll make my comment later. Go ahead, please.
Quickly,
No,
Sanjay.
I just said that I think alternate dispute resolution is the only way to attain any kind of closure and justice.
Yeah.
I'm just going to quickly come in because I got to drop off in 5 minutes, Sanjeev.
Sure, Jonathan.
I think settlement is also a form of justice, or mediation agreements are also a form of justice. It's just a collaborative form of justice. I know it's a big word I'm using right now, and this is what we talk about in the world of mediation advocacy. Coming back to the topic of today's webinar,
Right.
A mediation lawyer should first of all be convinced himself or herself about the idea of collaborative justice, where the fact we say that we have to move beyond what is right and what is wrong and collaboratively find something that we both feel is fair and just to both of us. And that's the concept of collaborative justice, where you find justice together. It's based on the principle of, once again, where you separate the person out of the problem, right? If you separate the person out of the problem, then you treat the problem as a third person in the room almost, right? Where now both of us, you and me, who have a dispute, we have to fight against that problem. So we're collaborating to find a solution against that problem, and that is collaborative justice. So I want to wrap up with this, Sanjay, because I got to jump off in 5 minutes.
No. Thanks, Jonathan, to have
I think
your views.
a lawyer must be someone who understands and convinced of the concept of collaborative justice, and then, of course, tries to convince their client.
Sure.
Thanks.
Sure.
Thank you,
Thanks.
thank you, Jonathan. That's really,
Thank you, Jonathan.
fantastic point of view.
Right. And I mean, having heard Vikrant, I think I was also having this urge to say, definition of justice itself has been, debatable. Simple point, as you said, a justice delayed is justice denied, right? We keep saying this, which means that at what stage would you consider justice getting delayed, where you can say that now it's denied? So these are, debates which probably will take us in a different tangent and maybe we'll avoid. And second thing, we were talking about the right and wrong. Now, COVID has been the best example when both the parties, I mean, parties in dispute, a simple example being landlords and tenants, they both have been blaming each other, I mean, in a COVID situation, where they said, I have been wrong, then the other party say, I've been wrong. Somebody was relying on that monthly rental to, the landlord, probably to, to as a sustenance. And the tenant was not getting his or her salary and he was not in a position to pay. Now, both had a grievance against what? So nobody did wrong to anyone, but they both were wronged. Now, these are situations where you are forced to see a 6 to some is 9 to somebody else. So if you are having that patience and if you really want to, respect somebody's perspective, be in their shoes and see it from a from a different perspective, from a different class, maybe you'll be able to figure out that, there is a sense in what the other party is saying. As Jonathan rightly said, that, if we can remove or detach the dispute from the person, we can actually humanize the issue and say, okay, there is a problem. The person is not the problem. The person is grappling with the problem. If we can identify the problem, keep it separate. Now, we together, you and me, are fighting for a solution for the problem, against the problem. So this entire dynamics change. Otherwise, if you own it up and you are like, totally engrossed in, then I think it becomes personal and then we're fighting with each other. So these debates, they go in all directions, but Jonathan, it clearly shows you've been a psychology student. So like, you are able to link those things, which every now and then, like, whenever we are part of any mediation session, we have to look beyond, we have to look through, and we have to see through, and we have to preempt, and we have to, appreciate somebody's perspective, which can be different and still be right. Now, so the moment you are aware of those situations, I think the whole dynamics of the entire room changes. Otherwise, we all, be it a advocate or a party, we all come with our clear positions where we say, I have to get this, and I have, I know that I'm right. I need to win. So it always starts from there, and a lot rides on the mediator, how he runs the process, how he navigates, how he facilitates, how he makes the people, the parties comfortable when they start going beyond their own self, and they say, okay, let me also appreciate that if somebody else is saying something different, maybe there's merit to it. So that point well taken. Now, on one side, I don't know, time flies. We are almost at 6:30, but if it's okay, maybe one or two questions probably still need to be asked, and especially let me check. Mr. Jawad, are you there, sir? You're on a mute. In case you can unmute and please let us know.
He's got all the answers. He never
Sorry?
appears.
He has
He's
all
got
the
all the
answers.
answers.
Yes, that's the point. So that was the reason, like, we were after him. But anyway, okay, I see him. Sir, I had put a question for you, and apparently you missed that. If you allow me, can I just repeat, and to the extent you can answer that? Okay?
Yeah, Sanjeev. Please go ahead. I'll try to answer. I hope I'm able to.
No, you would definitely. We know you have all the answers. Okay.
Yes.
2010, a lawyer called Mr. A.J. Jawad moved to mediation from being a full-time lawyer.
Yeah.
Okay. Ever since he's been, a mediation advocate, he's been a trainer, he's been a mediator. Now, what is that role which you have seen for an advocate, and how it has evolved over the period? Because someone like you who've been like, going to a court, and who've been part of litigation, and who've been like, getting into these arguments, and I'm right, I need to win it, versus a situation where suddenly you say, enough of that, I need to like, shift, the mindset needs to change. You need to now come to a collaborative, non-adversarial space. This shift, how easy or difficult, and what do you see the role of a lawyer today, a normal average lawyer who goes to the court every day?
See, I was following a part of the discussion, Sanjeev, because my signal was going on and off.
Okay.
But I heard this very interesting discussion on justice, right? And Jonathan had put forth his perspective. And see, I think the whole problem lies with the very definition of justice. Because when you talk about justice, you presuppose that there is a wrong that has been committed, and that wrong has to be undone. Correct?
Yeah.
Well, that fits perfectly when, when you're talking about, let's say, some violation of somebody's fundamental rights, or killing somebody, or taking away somebody's property. That perfectly fits the definition of justice. Because that is where the strong arm of the law has to come. The courts have to step in, and they have to do justice, which is becoming increasingly rare, but we are not going to comment on that now. But, when it comes to disputes, okay, if you and I have partners, let's say, okay, and we have a dispute. Now, the whole problem with this definition of justice, when you look at it from a justice perspective, is, in my perspective, you're the oppressor and I'm the victim. And in my in your perspective, I'm the oppressor and you're the victim, because you're looking at it from a justice perspective. Now, if you can just shift the perspective and see, as Jonathan rightly said, that okay, we have a problem, okay, and we have to see how we can solve the problem. That is when our perspective shifts, because now we are focusing on the problem and we are seeing that okay, let's find a solution to the problem. Okay, so there is a different difference between what is adjudication and what is resolution. Adjudication doesn't resolve; it only revolves. Okay, so it takes you on a spin, and you go for a long ride, and it seems to you that the destination is just not coming, and you go on and on and on. Whereas resolution is something where you end up being satisfied that okay, I have got what I can live with. May not be what I wanted, may not be exactly what I thought is the best thing for me, but I realized that what I thought was the best for me may not be the best for me, but perhaps this is something much better. So the question that I think any lawyer should be asking the client is, how long are you willing to fight? How long do you think this is going to take you to, take for you to reach your destination? Number one. Number two is, what is going to be the cost of this? How much are you willing to spend? It's not just the money. It's the opportunity. It's your peace of mind. It's your relationship. So calculate the cost and see. And the third question is, when finally, after all these travails, you reach your destination, are you really getting what you set out for? Are you really going to be able to recover what you're asking for? Are you going to be able to, supposing you're asking for a share in the property, are you really going to get it? What is the process you have to follow in order to be able to recover that? So if these three questions, if the client is able to answer satisfactorily, then you have a good case for opting for dispute resolution rather than dispute adjudication. Right? So thank you, Jonathan. See you soon.
Absolutely.
So that's the simple question. Now I had to, I have shared this experience earlier. I'm not going to repeat this, but there's one more case that I wanted to discuss with you, because my client was setting up a wind farm and he gave the contract of aggregation of land to a contractor. He had worked with the contractor previously and the contractor had delivered. But this time the contractor was not able to deliver and my client was furious. He said, I want to punish the guy. He's cheated me. Okay, he has taken me for a ride. He's not answering my calls. So I said, well, what would you like to do? I want to sue him. I said, well, there is an arbitration clause. We can invoke the arbitration. And my client asked the question, how long is it going to take? I said, I don't know. I don't know. How much is it going to cost? I said, I don't know. Okay. And then he said, what are the chances of getting back my money? I said, again, I don't know. He said, what do you think I should do? I said, let's talk to the guy. Let's see what he has to say. So I fixed up a meeting. In fact, I have written about this and that article should be coming out soon. So I called up because we had, by the time, some notices had gone and all that. And Jonathan rightly said it was not a notice for mediation. It should have been an invitation for mediation, but it was a legal notice that was issued. So a lawyer had replied to the notice and the reply did not contain anything except for the fact that my client had created hindrances and there were a lot of problems, blah, blah, blah. Now, I fixed up a meeting in Cafe Coffee Day with the other side lawyer and the client. I said, let's meet, because I don't want in your office or my office. Let's meet in a neutral place. So I met the guy. I asked him, what's the problem? I mean, what's happening? He said, well, sir, the problem is that I have paid a lot of money to the landowners. I have got the documents. I have given the documents for scrutiny by your client's legal department. And they have been raising so many queries that, it's impossible for me to comply with all those requirements because these are simple villagers who may not have those kind of records. And normally we don't go through all that. It's just a question of, giving them enough money to satisfy them and get the land and set up the wind farm. And I've done this earlier, but this time the legal department has created a lot of problems. So I said, why do you think so? He said the project manager asked for a kickback. He wanted money and I didn't pay him. So he had told the legal department. In fact, there was a young lawyer who was dealing with this in the legal department, an in-house lawyer. And this project manager had threatened the lawyer that if there is any problem with the land, your career is over. So he got scared and he started demanding all these, compliances. So I went back to my client and I said, this seems to be the problem. So my client said, let's meet him and let's sort it out. So we met, and finally what happened was we discussed this and we reached a conclusion. My client, because the contractor was bankrupt, he had no money. So my client agreed to pay him some more money. And we said that, we will agree to this and we will go ahead with the aggregation of the land and we will restrict the scrutiny to a certain level. Maybe 12 to 20 years of title will be enough. And that, we went ahead with that. So that sort of showed me that, this is where we are going wrong. Okay, that we are not looking at the problem. We are turning the other person into a villain. We are projecting the other person as a villain. That guy is a cheat, it's a fraud. He's taken my money, he's not done my work. Right? So I have to punish him. Now, this is the binary that comes into play. So when you talk about justice, we are talking about binaries of rights and wrongs. And that to legally define rights and wrongs. Okay, a wrong will not be a wrong if it is not wrong under the law. Okay, a right may not be right if it is not right under the law. Okay, so therefore, what we have to do here is we have to humanize the whole issue, the human element of the whole problem. Okay, how are we looking at this? How is my client looking at this issue? What's important for my client? What are my client's real interests? Is it to punish the guy? Is it to terminate the contract, or is it to go ahead and fulfill the contract and preserve the relationship and get the job done? So this is a very simple question that we need to ask ourselves. Okay, are we doing the right thing? But here the problem, I'll just say this and I'll stop. The problem lies in the legal education system that we have. Okay, we are trained as gladiators. We are trained as problem inflamers. We are not trained as problem solvers. And this is where I have always been urging that our law school curriculum has to be changed to make us problem solvers. And mediation training should be an integral part of our law school curriculum because that is an essential tool in the toolkit of a lawyer. It's like calling a mechanic to repair your car. The mechanic comes and takes out a hammer and says, this is the only tool I have. And that's what we are doing as lawyers. The only tool we have is adjudication, litigation, whether it is arbitration or court system. But that's the only tool we are using. What about the tool of mediation? Why not? I'll stop there. Thank you.
Thank you. So that was words of wisdom as expected. Thank you. Vikrant, you are fine if I put another question to you, probably the last one, and then we
just one sec. Sorry. Before Vikrant answers, because when you called out to Vikrant, I was reminded of what Vikrant said in the beginning. He said, you have to give up something. Yes, maybe. But what I'm saying is, it's not always a compromise. Collaboration is not always a compromise. You may not have to give up because mediation gives you an opportunity to create value at the table. You can add more value. So the problem is we go under a fixed pie assumption. That is one of the cognitive biases that we go with in a dispute. Okay. Right. But expanding the pie is a concept that mediation provides for. Okay. So you create more value on the table. You try to bring more value there so that you get what you really need, not what you want, but what you need without really compromising on your core interests. That's all. Thank you, Vikrant. Thank you. Sorry to interrupt.
And just to add to what you said, the moment somebody says,
Jawad, one question.
Okay, yeah, I'll just complete,
Just one question to Jawad.
Go ahead.
Yeah. Jawad, you there?
Yes,
yeah.
yes, Pritesh.
Jawad, I've got an idea in my mind which I've been working for a long time. Okay. You just said that, the legal system, the legal colleges need to be kind of, integrated into this system of mediation, right? Don't you think, my personal point of view, that, I think it should be inculcated in the school system itself, probably in the, secondary phase after 6th, 7th standard, probably 2 years, where you can start talking about, because that's when people learn. That's when people learn what to do and how to deal with issues. So when you give them an issue at that time, saying that, okay, fine, there is an option to resolve rather than just fight. Isn't that the appropriate state?
I would go one step, Pritesh. I would say that the emotional intelligence training for children should start from the primary classes, and it should be a continuing process. Okay, right up to secondary school level, where they are taught to discuss and talk to each other, try to understand each other, listen to each other's perspective, develop the core empathetic values, the value of empathy. That should be taught to the children. Okay.
Exactly, because when we were growing up, we used to have every day, first half an hour, either moral science or, if you were in the same, you have catechism, whatever. But today we don't
Those
have
were the
that.
days. Those were
Yes.
the days.
Yeah. So what we're really losing out
Yeah.
is on actually, telling these kids that there is resolution as an option.
No,
Right?
see, I had a slight difficulty in accepting the moral science classes or the catechism classes because morality is a very relative concept, and so is religion. So, but what I do believe is that the training in emotional intelligence, the concept of empathy, that you listen to what the other person has to say and you sort out your issues. So there are many ways. I think many schools abroad are implementing that already. Only we are not doing it,
They are.
and
Yes,
this
they
is
are
where I
in
think a
many,
lot
many
of
ways.
politicians and even our judiciary would do well with that kind of a training.
Right.
Yeah, so there are actually concepts going on in UK, US, and Wales where they actually bring this concept in.
Yeah.
Right? We are not
Right.
doing it.
We are not doing it.
No, so there's a lot of things which we need to do, and we'll definitely do one day. So let's keep our hopes high. And Jawad, just to add to what you said about the giving up thing, right? It brings us to a debate of letting go and holding on. Right now, that's where, like, when somebody, you are able to read a psyche of someone who would say that, okay, we'll have to give up something, which means once you are part of a mediation or a discussion, you would actually understand what is worth holding on and what is worth letting go, because you can't have the cake and then eat it too. You do not get solutions like this.
Yeah.
So you have to appreciate somebody else as well. I mean, I keep giving example of COVID, where nobody did wrong, but everyone was wronged. Now, in those scenarios, you always have to take a step forward towards each other and figure out, because as we say, mediation is collaborative, futuristic. We have to hold on to our relationships and all. That's the only way. You cannot, like, grab everything. So letting go and holding on, what exactly one needs to, that's only after you discuss. So communication, conversation, right? And being open-minded, the mindset has to change. So those are important points.
No, that's where, Sajid, just to add one point, I'm sorry, I'm standing in the way of your question to Vikrant. The most important thing that we don't understand, even in our mediation training programs, is the importance of the neuroscience and psychology of conflict. Okay? How important it is to understand that a person in conflict is like Arjuna looking only at the bird's eye. Okay? It is very good when you're having target practice, but it's very bad when you're looking at a conflict, when you're looking at a relationship, when you're looking at each other. Because there's a lot of things that are happening around you, but you're so focused on the conflict that you're losing sight of all this. And that's where the mediator's talent, skill in bringing about shifting the focus from that bird's eye to the whole situation around, giving the balcony perspective. The balcony perspective. I'll just stop.
Right. That's where we say, like, we are focusing on that black dot on the white canvas. right? I mean, those examples we keep giving. So absolutely, yes. So Vikrant, if I may come to
Yeah.
you.
Yeah.
So the question what I had in mind, and probably the last one, as a advocate, as a lawyer, you go to the court, and like, we have been talking about, at the right stage, you would want to tell your client that, if settlement is an option, why not? What happens to the voluntary aspect of mediation as we keep defining? There's a very constrained definition which we have all kind of grown up now. Last 10, 15 years we've been hearing that mediation is a voluntary concept. And then, in spite of that, the draft bill actually spoke about mandatory provision for mediation. And we still have Commercial Codes Act 2015, Section 12A, which says mandatory, right? Pre-litigation mediation. What is your take on this entire mediation,
So
the voluntary and the mandatory debate?
I'll tell you. See, firstly, okay, let's come to the first part of the question in terms of when you tell your client whether it's voluntary or not. Now, when you tell your client the pros and cons, but eventually it is the client who has to volunteer whether they want to eventually, after getting a feedback, getting an advice from their lawyer, eventually whether they want to go ahead or not. So eventually it is, and same with the other side, and both parties have to be on the same page as far as that is concerned, as far as mediation in the middle of a matter is concerned. So that's where the voluntary part comes in, because sometimes clients don't know exactly what is mediation, or they've heard about it, but they really don't know, how it works. And that is where lawyers come into play and tell them that what is mediation and whether their case is a fit case to be mediated, as opposed to continuing with adjudication. Now, once you do that, that is where the client comes in and says, okay, yes or no, and that becomes voluntary. Now, coming to the second part of your question on the Commercial Courts Act and the Section 12A. Now, the idea of court of course the parliament passing such a law, passing such a provision in a law was try and settle it out of court if you can. Try and maybe, because the idea I think was that not everybody knows the pros and cons of mediation. So when it goes automatically in mediation, parties get educated on that, because today when I know it's voluntary, a lot of times you try and fight it out in court, and it's only in the course of the hearing over a number of years that you decide to go in for mediation. But here the idea is to try and convince the parties right in the very beginning. So which is why which is why they've put this provision that you first go for mediation and try and settle it. Now, when it goes there also, the parties ask, okay, of course, there's an exception there, there's urgent relief and so on. But if now when you go there, the parties ask, what is this? And that's when the lawyers say that, okay, so you can't directly fight it out in court. There is a provision for mediation. And therefore, the parties have the option to try and sort it out without going to court, because otherwise this is the court fee also that you're paying and so on. And, if you can sort it out, why not? Now, there again, you see, if parties are not interested in mediation, there also, a lot of time, yes, the person who's filing the suit has to voluntarily, apply for the mediation, has to mandatorily apply for the mediation. But if the other side is not interested, or even the party who's done, then a lot of times the mediators get termed as non-starters, and a non-starter report gets generated. So there again, even though that provision is there, it's more like to educate parties that try and see if you can settle it out of court. Why coming to the courts and fighting it? But again, if parties voluntarily don't want to do it, a mediation can always go, a report can be, you can inform them that, see, I don't want to mediate it, and you make it a non-starter, and a non-starter report goes to court. And then you go back, and then, of course, if parties during the course of arguments eventually voluntarily decide to come back, that can also be done. So again, therefore that voluntary thing eventually does come in. It's the mandatory provision is there to put the parties to try and attempt to put the parties in the same room. But if the parties don't volunteer to do it, you don't have to do the mediation. You can then go to court and the non-starter report comes in.
Point taken. And what is coming out of this discussion is something very important, that there is a difference between a non-starter versus a failed mediation. If you're not even starting, what happens to that awareness? You've not even understood what exactly could have happened. So a non-starter situation is a very sad situation versus a failed mediation, which should not be taken as a taboo. But in the same breath, if we respect this clause of mandatory, so try it out, you'll probably understand the pros and cons. Frankly, you ask me as a mediator, I don't know what the cons can be, but still, it's important for a partner.
No, I'll give you an example. Like, let's say you have a lot of public sector undertakings, who are involved in contractual disputes, and those are all commercial disputes.
Yeah.
Now, a lot of those, from personal experience, I can say, I can't otherwise say so, but from personal experience, the reason why they become non-starter is because the moment, the other party comes forward and, and of course, there's a difference, like you said, in non-starter field, they are happy to to comply with the provision of, okay, that's a legal provision, we'll comply with it, we have no difficulty. But then the moment, you ask them, okay, if you want to settle, what are your terms? That's when the question comes that, okay, this is the contract, we're absolutely correct. If I filed a suit of 5 crores, I want not 1 penny less. Yeah. And I want 5 crores with interest. And that is where then the mediation becomes a failed mediation.
Right.
And the matter ends up, going to court.
Fair point. So and what will be your take? Like, when we say this entire debate of mandatory and voluntary, but the Umbrella Act, the main Mediation Act, now 2023, has restricted itself to having initiated the mandatory provision earlier in the draft, but eventually what came out was a voluntary. Right. Now, a specific act like Commercial Courts Act says mandatory, but the Umbrella Act says voluntary.
No, but if you look at mediation, so if you look at Mediation Act, it draws out an exception for the Commercial Courts Act. So it specifically mentions, if you look at the text of the Mediation Act, it specifies where any provision of law makes a mandatory mediation, and they've mentioned about the Commercial Courts Act there. So they've clarified that stand that it's voluntary process, but where the Commercial Courts Act is there, that provision will govern as far as mediation is
Fair point. No, okay. My statement was different. I said, why was there a need for a U-turn where the draft bill said mandatory? Because jurisdictions like Italy and Greece, they have initiated a mandatory provision. For example, MIMS, which is mandatory interim mediation session. These are two two sessions are important in Greece. Now people get to know, right? So this mandatory thing could have worked at the umbrella level. This mandatory thing could have worked at the umbrella level as well. So I said,
the government I'm sorry, the government was not willing to accept.
Sorry?
Government was not willing to accept that it will be mandatory at all.
No, so that's the debate. I mean, that's the reason we are debating, right? I mean,
I think that's where yes. So mediation, the Act says it's the government. They've made it voluntary.
So sorry to interrupt, Vikrant. I just have to take a hard stop here because I have a class beginning in a few minutes.
Yes. So we are about to close.
We are also closing. I have to also leave.
I understand. We have already
See, the Mediation Act has a voluntary because they've left it to the parties to get senses to prevail and to take a call whether they want to mediate. It's formalized the process of mediation through the Act. But the Commercial Courts Act, on the other hand, while they make out the exception of bypassing mediation if you have urgent relief and you can't wait for mediation, you need an interim protection or something like that.
Vikrant, something that you said is very, very clear, right? And I agree with that. Everywhere the problem is that people are scared of going to mediation when the Vigilance Department is, and this is something that even Justice Arvind had said, that, the problem is people are scared. They want to,
this specific to government, right?
They don't want to take the chance.
Yeah, fair point. And in the initial phase, we said,
they just say, okay, fine, let somebody else take the call.
Right.
We will not take the call because tomorrow my pension may be jeopardized.
So that's the reason whenever we discuss government, we said this is a different debate. We cannot include that situation in our regular discussion because it requires a specific treatment. And of course, unless
and I'll tell you the reason why, coming back to your question, why also probably there's a mediation. So Commercial Courts Act, if you look at the preamble as well and the debate behind it, the idea was to expedite hearing of commercial matters because of high stakes involved. Right. And I think as a precursor to that, the mediation has been made mandatory because mediation, is part of that whole thing of a quick resolution of the dispute. The matters in Commercial Courts Act have much shorter dates compared to regular suits that happen in court. And
Right.
I think, and that's the reason why, there was this attempt to try and get the parties to mediate, because then that even expedites the process of resolving a dispute between commercial entities quicker.
It does.
So
Sure.
I think that's the idea why they introduced it. But at the same time, that voluntariness does come in, because if party doesn't want to do it, they can always convey their displeasure at that point in time and go to the court immediately, rather than waiting for that mediation to take place.
Okay.
Thank you. I'm sorry. I have to.
No, that's fair. Thanks a lot. Thanks a lot, Vikrant. And thanks everyone who patiently been, with us for about an hour and a half.
Thank you so much. Lovely conversation.
Thanks a lot. And Pritesh, please get well soon. That was a heroic effort. You still have, you've been there all through the session. So that's really commendable. But anyway, thank you. I see Mr. Suresh Kumar and Mr. Rao and, a few other names I know. But then thanks everyone. I think that was wonderful. We wanted to make it interactive. And that was the reason, the questions didn't follow a particular sequence. Whatever made sense at that point in time as a follow-up, we chose to continue with that. So I think there must be some good takeaways with regards to mediation advocacy, and something similar has to come again, because I think the time was less and we had few different questions which also had to be addressed. But then I'm getting some messages that probably we'll have a follow-up session soon. So for now, I think I'm thanking everyone once again from IMF and
Please do
the
have a
thanks
follow-up
to
session on
ILA.
this. Please do have
Sorry?
a follow-up. Sanjeev, please do have a follow-up session on
Yeah,
this.
we'll
because
have to have.
This is something that we really, really need to address.
It requires, give me a choice. I don't want to even put a timelines to it. Let's come, let's talk, and let's continue the discussions. Every time we have to look at at the clock and say okay, 10 minutes left, 15 minutes left and all that. But point is, yes, we all have our own priorities and all, but somewhere we need to take out some time, get involved with these discussions, debates, because something will come out of it. Whether we're talking about the government, we are talking about private sector, public sector, mediators, mediation institutes, mediation advocates, the lawyers, the students, everyone is relevant. Everyone's a stakeholder. So we have to take everyone along. And that's the whole idea, how and why IMF actually exists. And that's what we are trying to do, being that umbilical cord and trying to connect all the dots. And thanks ILA as a supporting partner. I think that was nice to have your collaboration and increase our reach to people across. So thank you once again. And now we'll be closing the session.
Thank you, Sanjeev. Thank you, Sanjeev, for a fantastic session.
Thank you, sir.